National Signal Bureau, NSB, Kwabena Edubuahen, the court case, no latest update on Kwabena Edubuahen, no, ya projecte the ato ye screen no enchen the amamano. NSB 49.1 million Ghana case. Abusia, court rejects Edubuahen's WhatsApp chat with AG's witness as irrelevant to charges. Court rejects Edubuahen's WhatsApp chat with AG's witness as irrelevant to charges. Abuzuya Kwabena Edubuahen, eche say wakom akom baby or the befebia emfa enka or the WhatsApp chat be ekwa kopiem as ne evidence on the third accused person as is ano or yes state witness no abusuya na ode sa chat no ekoko piemu ewo court no abusuya ya bo de ato agua enye asem keto akro enti no Kwabena Edubuahen de se ode legit document mema na nya na adwen se opese oye fakadam bia ewo court na judges na omutine case no ne so no omonso very intelligent enye asem keto enti no ne WhatsApp chat it's or the cocoa PM court as an evidence no abusuya court no about to na mommy yanko na yanko kweti a court cases ni bia happen ano abusuya mommy yanko na yanko kweti on subscribe na hit on the notification bell madam ase.
So this week when you see me in Thai, don't be.
That should tell us
I've just tried.
You're on a new path.
Yeah, I'm trying small.
Okay. So in the small, what's the smallest victory for Chemahun to me? Does he have it?
So yesterday, Court of Appeal. So I always talk about the fact that the hierarchy of the courts are there for a purpose. So from district court, circuit court, high court, court of appeal, and Supreme Court, there is a purpose for each of the courts. Each of them have distinct jurisdiction or powers or authority to deal with their cases. So when you go to, let me start from the high court. When you go to high court, the cases that you go there and face is a single judge. Apart from the fact that it's a high treason, that you see 3 judges sitting. But in all times, it's one judge. So if that one judge takes a decision and you are not satisfied with it, the system doesn't want to close it for you. You should have another opportunity.
To seek
and that absolutely. And that opportunity is not for you to
appeal.
Absolutely. It's not for you to go and meet 2 judges. If they are divided, then you have one. No. You go and meet 3
judges, yes.
And the chances are that 2-1 or 3-0. And they will review the work done by the single judge. Even if at that you still disagree with the decision, you go to the Supreme Court and meet 5 judges. So from 1 you go to 3, from 3 you go to 5. Even the 5, if you disagree, you can go and they will make it 7. Then that one after, there's nowhere for you to go again. So review that.
And unless of course there's a review.
Yes. So from 5. If you disagree, you go and they'll add 2, review,
and
7.
Then they review.
After 7,
review, then it's still the same stance.
And
then.
One, yeah.
And if you are lucky, and then
if you are not lucky, then the best place maybe you go to the Hague.
or the best is go to Nananum.
They're going to give you a case to Nananum and then they'll look at it. But Chairman, to me, the day before yesterday, he was at the High Court. And when he was at the High Court made an order earlier after making the ruling that, look, prosecution has made a case against you, so open your defense. He said, look, I am challenging that by filing an interlocutory appeal against the dismissal of the submission of no case, which the court has ordered him to open his defense because prosecution witnesses have made a case against him. He said, no, I disagree. I'm going to the Court of Appeal to challenge that. But before I get the Court of Appeal case done, I don't know what the Court of Appeal or when they will hear my case. So hold on to the case. Don't let me open my defense. Let's wait for the Court of Appeal because the Court of Appeal is higher than the High Court. Let me go and come. When I go, whatever decision they will give me, I'll come and communicate to you. If they agree that the decision that you took is right, fair enough, we'll continue. If they say it is wrong, hooray, victory for me. The High Court says that no, because the mere filing, he came to the High Court with a stay of proceeding. the court is saying that the mere filing of an application or an interlocutory appeal at the Court of Appeal doesn't constitute an order on the High Court to stay proceedings. No express order. So let's proceed. Anytime the Court of Appeal is ready and they come up with their decision, it will not hurt what we are doing here. But if we hold on and the Court of Appeal say go and continue, if we have stalled the trial, rather we have delayed and all of that. And the court pointed to the ambulance case at forcing Richard Jakpa and then Sylvester Nemana, where the court dismissed the submission of no case, but he appealed at the Court of Appeal, and the trial was progressing, was ongoing. And when the Court of Appeal ruled that or took the decision that they ought not to be called upon to open their defense, they acquitted them, and then the trial, the High Court truncated. And finito, we are done. No, nothing has been done. That is the state that the court is saying. You be at the Court of Appeal with the order for me, for you to open your defense. But I am proceeding with the trial, so open your defense. So that state of proceedings was dismissed. He said, look, the reason the hierarchy of the court exists that if you turn me down, I can go upstairs. So yesterday, through his lawyers, they were at the Court of Appeal, 3-member panel. Justice Georgina Mensah Dacha was the one presiding. Justice George Widi was also a member of the panel. And Justice Ayite Yaman. These 3 welcome submission from his lawyers led by Andy Apiakubi. So you see Andy Apiakubi. And this is the premises of the Supreme Court moments after the case. The argument was simple. If you do not stop the trial at the High Court, Chairman Wontumi will suffer an irreversible prejudice. Because in their mind, they think that the ruling that the court made, there were certain words that the judge used which sought to have preempted or presumed him guilty before even him opening his defense. Deputy Attorney General Dr. Joseph Shremsai, who represented the state or the Attorney General, opposed that and said, look, for a stay of proceedings to be granted by the Court of Appeal, there are some thresholds, some elements, 5 key elements that ought to be looked at. In all the 5 grounds that they advanced in court, none of them touched on the threshold, those elements. And so no exceptional case has been made for which the court should exercise discretion in its favor. The panel said, look, we have read the processes that you have filed. We have heard oral submission by the parties. We have read the ruling of the High Court, and at this point, we do not think that we need to interfere or disturb the ruling of the court. The High Court has only made a ruling. Dissent. Absolutely. And so what is the status quo remain? What the High Court has said is what the court is stamping on. So that request or repeat application for stay yesterday was dismissed. But moments after, of course, Andy Apiakubi, he's used to that. Once this case is over, certainly he'll speak to the media. He said, look, we'll consider the ruling, and if possible, we'll go upstairs. So from Court of Appeal, it is possible that they go to the Supreme Court. So let's hear from Andy Apiakubi.
Repeat it or go back to the instant court to prepare our witness statements and continue with this the case and see the outcome of the case itself. So in a nutshell, this ruling brings us to the end at the Court of Appeal in respect of the application for stay. We'll have to go back to the chamber and look at the options, and then we will let you know which line of action we'll take. For now, like I said, we are open to 2 lines of action. One is to go up to the Supreme Court, and the other is to go down to the court, High Court to continue with the proceedings.
Okay.
So Andy Apiakubi. And this is the summer boy leg of the case. In bits, I will tell you about the Tano Nimbiri Forest Reserve case also. And let's move on to
the Wesley girls.
Yes.
Yesterday there was no show.
No show.
Why?
Director. Okay, so that's the scene, the premises of the Supreme Court. The GBA president, Defo Agate, right? And then, so all these people, she's a board member of the Wesley Girls High School, and that is Aziz Abdul Gomda, lawyer for the applicant Shafiq Osman, living the short over there. So yesterday they were at the Supreme Court, and the reason they were at the Supreme Court was for a hearing of 2 are applications. Because one, the board of governors of Wesley Girls says that we don't have capacity to sue and be sued. So we have no business being part of this case. On the back of that, strike out this rate. Then there's also the Catholic Bishop Conference who are joining us, although they filed an amicus brief. The lawyers of the applicant are saying that, look, there's a process that if you want to come to the Supreme Court, you come by way of seeking leave of the court before you do so. You didn't do that, so that is irregular. And those are the two applications that yesterday the Supreme Court was expected to deal with. But I understand the case was not called in open court. Our understanding is that a member of the panel is indisposed. So April 28th, they will come back in relation to that. So that is what happened in relation to the Wesley Girls School, that issue that has to do with the religious rights and all of that. So no show at the Supreme Court yesterday.
You know, yesterday there was a news item about Abu Treka.
Yes.
And then I saw there was a statement also flying around from some quarters that it was not actually the case, and that will be, the bail application will be reviewed on April 27th or something. What's the real detail on the story?
So yesterday, before Justice Halima El Alawa Abdul Basit, his lawyers appeared. They moved a motion, and that motion is for bail. They argued. Prosecution also stated its position. The judge was of the considered view that at this point in time, Abu Treka or Frederick Ishen, popularly known as Abu Treka, be granted bail. And the bail sum was 30 million Ghana cedis. It doesn't mean that he's going to pay 30 million Ghana cedis.
But with surety.
Absolutely. So when you are going to the bank to go and secure a loan or for a facility and all of that, they ask you for collateral. So the collateral in the language of the court is what is termed as the sureties. So you are not going to pay that 30 million, but you are looking for two people. The sureties, two sureties. These two sureties are to be justified. They need to justify that when you are nowhere to be found, the 30 million they can pay, or they have to pay. Those days you go to jail in their state, but now they have reviewed the law, amended the law to the extent that now you have to pay. So these two people are not supposed to be any other persons at all. It should be people who have landed property, and so they look for land, buildings, landed properties, and things that, and they value it. They have to evaluate it. So that's why you'll be granted bail right now, and it takes you time for you to execute, because investigators will have to go and inspect these facilities or these properties in the name of this particular. And the people will go and even go and borrow other people. Some will also bring some fake documents, and they need to ascertain all these documentation before, when it is clear that yes, the processes, the documentation, and the properties that they have you they amounted to that amount that we are talking about, then officially your bail condition, or you have executed your bail, and then you go. Yesterday, as of the time that I was leaving the premises of the court, after 4 p.m., he has not satisfied the conditions. Absolutely. He has not satisfied the conditions. Satisfying the conditions means that you come to the court and they sign it off at the registrar's office. So 30 million bail sum, two sureties to be justified. And the court is saying that he had to deposit all his traveling passport or documents, not limited to his passport, all traveling documents.
So it could be Ghana card.
Absolutely. To the registry of the courts. And he will report to the police CID headquarters any other day. So you come today, tomorrow you will not come, then you come the following day, and all of that, in that time, and all of that. So that is the bail conditions that have been set for. He has to come in. Did you say he has to come to any CID? Yes, police headquarters. Wow. Yes.
But I thought he lived somewhere.
That one there.
Hey, okay.
You have to find a way to report.
So in this life, whatever you do, just know that
there
someday
are
the law will catch up with you. Actions come with attendant consequences.
Yes. So that is it. So wherever he may be living or wherever he lives, just have to make sure that you
commute.
Yes, to the police. Once you renege or you don't comply with any of these conditions, all that the prosecutors would do, or is to draw the attention of the prosecution they come to court and say that you are not complying with the orders of the court. And once that is come to the attention of the court, the chances are that your bail would be revoked. And once it is revoked, before so we the back.
Interesting. Let's look at the Boahen case.
National Signals Bureau.
National Signals Bureau.
Yes.
What's the latest on that?
So yesterday was an interesting day. It was an interesting day because a WhatsApp conversation between Kobne Boahen and the witness, Edith Ruby Adumwa, came to the fore. It was the subject matter of cross-examination yesterday, where lawyers of the accused persons are holding the view that there were some requests, financial requests, some financial conversations between the witness in the box and the accused person, where some requests were made to him for some monies to do certain things and all of that. So when she sends the message, there's a reply, okay, this amount, I have increased it to that amount and all of that. So in their view, they want to use that conversation to tell the court that, yes, you are saying that the man has stolen amount in the sum of 49.1 million Ghana cedi. There were some financial transactions that took place that, you know, the witness is the director of finance at NSB, National Signals Bureau. And so in terms of how to spend money and all of that, it passes through her and all of that. So yesterday she admitted at the point that, yeah, that was a conversation between her and her former boss. However, the lawyers intended to tender it in evidence. Tendering it in evidence means that the court have now accepted it to use it as a document when taking decision on this subject matter. The DAG, Deputy Attorney General, Dr. Jesrem Sai, opposed to that and make the grounds that he raised was relevance. Relevance in the sense that that particular WhatsApp chat, what role does it play in the charges that have been leveled against the accused person? He makes the point that whatever conversation that they have had have no bearing on the charges that have been leveled against the accused person. Justice Achiponga, Francis Achiponga, who is a justice of the Court of Appeal, presiding as an additional High Court judge, made a ruling on that objection and sustained the objection. And the court's reason was that, look, we have seen the WhatsApp chat. However, what that conversation lacked is that we're only talking about money. There's nothing that shows that those monies that were being talked about were even paid. Number two, the case before the court and the conversation as what is contained in the court has no bearing with the charges that have been leveled against the accused person. On the back of that, that WhatsApp chat, the court said, cannot be admitted in evidence, and same was rejected. So 27th of April, that's on Monday, they'll be back in court for further cross-examination. The indication is that this witness has spent so much time in the witness box already. So the court is saying at least in 2 sittings, lawyer Samuel Atacha, who is defending the accused person, at least should conclude the cross-examination, and the next witness will also mark the witness box.
You a while ago you mentioned that you bring me the other leg of Chema Untumi's case. That's
yes.
Tano Nimri Forest.
Absolutely. Yeah. So the first one is Summer Boy.
Yeah. And
the second one is Tano Nimri Forest. And this is the case that the general manager of Akunta Mining has agreed to become a prosecution witness. To become a prosecution witness. And the expectation is that he's expected in court today to testify. So that trial officially is beginning today before Justice Ruby Aite. And this afternoon, that leg of the case is also beginning. So from one court to the another court. Chairman Wontumi will also be at the court. No, that's the NSB case and all of that. So today, officially, we expect the trial in the Tando Nibre Forest case to begin at the High Court. So that's one of the cases that we should keep an eye on. Then Skytrain. Yeah. Yesterday he came home. The witness was in the box. Cross-examination continued today. It is continuing before Justice Audrey Kokuriti will be there to bring you more updates on that. Cecilia Dapa. Yes. Cecilia Dapa's mate.
That story has traveled, huh?
So one of the reasons this case will still even travel longer is that the accused persons are 7. If all of them are opening their defense, imagine patient Buju, she's the one with the down yellow, is calling 5 witnesses. By the time he's done with 5 witnesses, all the other accused persons will have to cross-examine that witness. Prosecution will do, all the other accused persons will have to do. So 5 witnesses, when he's done, the another accused person said, okay, I'll call 10 witnesses. The other accused person, so you can just imagine. But what is clear is that the investigator in this matter is continuing with his evidence in chief, the police officer, before Justice Marie Lewis Simon. So we'll be there and we'll bring you updates in relation to that. So that case is still active, is still pending. At the point in time, they've considered plea bargaining, but as at now, there's no communication to the court as to whether they have agreed on anything or not. And the witness is telling the court how huge sums of monies were, as it were, used to purchase certain properties, 4-bedroom houses, stocked with a well-furnished interior decor and all of that. And I'm sure that anybody who had the opportunity to get a new place, things that you would think also how to make your room look so nice and all of that. And the accused person, allegedly, when they were arrested, were living lavishly. Monies were retrieved, $10,000 and all of that. And of course, Buffer stock,
yes.
Hanan, Hanan, Wahab, Abdul, Wahab, Adam. It's not our Hanan, though. So he's back in court, and he's in court today. What is expected to happen today is that the case management conference will continue before Justice Francis Apangabonu Achiponga. So these are the cases that we are expecting in court today, and some others that we may chance on them.
Absolutely. Thank you very much, Captain.
Okay, Abuzuya wene ensema ekoso ewo political highway so kwabena Addo Boahen and I did the latest update at the bremu na enye asam keto akra. Ne WhatsApp chat no Abuzuya court no are rejected enye easy cry. But I want to say some je pene kokoti ensema ya the bremu.